Did the judge in the George Floyd case just disqualify the prosecutor's office? The same prosecutor's office who's responsible for prosecuting the 4 cops who were responsible for killing George Floyd. Something interesting is happening. We learned on Friday that in Derek Chauvin's case, if you remember Derek Chauvin, he was the cop that had his knee on George Floyd's neck, the same one that we saw in the video, the same one that people were screaming at to get his knee off his neck because he was killing him. He was charged with murder. Now, his case is going through the court system. On Friday, September 11th, we had an omnibus hearing, which is sort of a big hearing where the court listens and hears and resolves a lot of things all at the same time. We had that hearing on Friday. We know a little bit more about what took place. Now, because this hearing happens behind closed doors and because it was done orally, a lot of this stuff happened right in the courtroom, and we don't know much about what happened other than what we can glean from the court record. So if you look up in Minnesota, if you look up their court records, you're going to see that you can find information that looks like this. This here is an actual screenshot from the records that we just looked up today on September 14th, and we can see some interesting stuff happen on Friday. So let's take a look. If we look up top here on 9/11, we're going to see that the omnibus hearing was held in front of Judicial Officer Peter Cahill, held on the record. There were a couple impositions. The court imposed some requirements on Derek Chauvin. Now, again, he's the cop who's responsible for putting his knee on George Floyd's neck, resulting in his death. Couple conditions here. Number one, he's got 2 different bail settings here. He's got one for $1.25 million with no conditions, and he's got bail or bond for $1 million with conditions. And so he's got some other limitations on his ability to leave. He can't, say, for example, he can't leave the state of Minnesota without court approval. He has to remain law-abiding. He has to sign a waiver of extradition. He needs to make all future court appearances and so on. So this is one of the things that the court resolved. They always do this. They set release conditions and they set bonds and they do a lot of other things. But something else must have happened here. Now, we can't see it from the minute entries, but we can see that the government filed a response today. Take a look. You can see down here on 9/14 that there was a new motion filed and an affidavit, and we have e-service. So that means that these motions were filed in the court and they were actually served on Derek Michael or Derek Michael's lawyers. These are presumably going to be ruled upon on 9/18, so in a few days' time. And what are we talking about, right? This motion was filed by the government, and what does it say? Well, it is surprisingly interesting. It actually is what's called a motion for reconsideration. So remember, in any criminal case, you've got 3 parties. You've got the criminal defendant, that's the person who's been charged with the crime. You have the prosecutor's office, they're the ones responsible for prosecuting the crime. And then you've got the judge. You've got the judge who's supposed to be the neutral arbiter between the 2 parties. Well, what we have going on here is something happened on Friday where the defense may have made a motion or the judge made a motion of the judge's own accord, and the judge issued a ruling, and the ruling was adverse to the government. The ruling went against the prosecutor's office. And so in this motion, what we're talking about is the prosecutor's office asking the court to reconsider. It's called the state's notice of motion and motion for reconsideration. What are they asking the court to reconsider? Well, on Friday, presumably, the court entered an order prohibiting the participation of Michael O. Freeman and others from the case. So the court went through and they said, you're not allowed on this case anymore. You have been disqualified. That is our final order. And the prosecutor's office is coming back and saying, hold on. Wait a minute. We're going to ask you to reconsider. We don't want to be prohibited from participating in the case. And you may say, well, that's not that big of a deal, right? There's probably a lot of people who shouldn't be participating in this case, but not this guy. This guy, Michael O. Freeman, which the court is excluding, is in fact the main county attorney for Hennepin County, which is where George Floyd's case took place. So Michael O. Freeman is the lead prosecutor. This is the guy who's responsible for prosecuting a huge portion of crimes out of Hennepin County. He's the Hennepin County attorney, and he is sort of the chief prosecutor in this area of the law. Here is a little bit more information about this fellow, Michael Freeman. He is the elected Hennepin County attorney, served as the Hennepin County attorney for 14 years from 1991 through 1999, also again since 2007. And you may remember this guy. You may have seen him speak. He had a couple of sort of interesting press conferences conferences where he would come out and be really angry and then sort of indignant that he had to charge these cops with crimes. And it was just kind of a weird thing. But he was on this case, presumably because he is the county attorney. He got involved in it because he's so high up, and this is such a high-profile type of crime that he got involved. So what the heck? Why would he be disqualified from this thing? Well, something had to have happened. What are we talking about specifically? So here is from the government's motion. So again, this is the prosecutor's motion. They're filing this to the judge, and they're saying, Judge, we don't like what you did on Friday. Please, please, please reconsider. And again, because we don't know really exactly what happened in court on that Friday day, what we're going to do is we're going to glean more information from the government's own motion to the court because they're going to be responding to what the court said. So let's take a look at what the motion says. It says here that they're asking the court to reconsider. They're citing some case law here out of Minnesota. The order that by the court's own order would have otherwise prohibited Hennepin County Attorney Michael Freeman, his deputy chief, Andrew Lefevre. We've got a managing assistant county attorney, Amy Sweezy. We've got senior assistant county attorney, Patrick Lofton. So all four of those people, which is going to be the chief, the county attorney, the head honcho, and his three sort of deputies, are all going to be disqualified from participating in the prosecution of this case. The court's ruling was premised exclusively on the finding that they violated the advocate witness rule, which we're going to talk about when they had a meeting with Hennepin County Medical Examiner, Dr. Andrew Baker. And they're also going to the court is saying that they are disqualified because this was something that was handled sloppily by their office. Look at this double red line marks right there from yours truly, because you don't see this type of language in motions. They're saying that the judge is saying that these four attorneys violated the advocate witness rule because they were present in a meeting with Dr. Baker and there was no non-attorney witness present. That is sort of the crux of what the court is saying happened. So they're saying that this meeting took place, the court's upset about it, and therefore these four lawyers who were involved in these meetings are going to be disqualified. So that's sort of the high-level overview of what the government is asking the court to reconsider. Court said you're out. Government is saying, nope, let us back in. Please, please reconsider. So what is this rule that the court is talking about, this advocate witness rule? What does that actually mean? Sort of a little bit of a difficult concept to grasp, but I'm going to try to lay it out as easily as I can. But let's look at the rule, the actual statute, the law, the rules that the government cites in their motion to the court. You're going to see here that it says the advocate witness rule provides that a prosecutor cannot be a courtroom advocate for the state and a witness in the same trial. One more time. A prosecutor cannot be a courtroom advocate, so that would be like a lawyer, for the state and a witness also in the same trial. It goes on, it says there's some long-standing rules, and it also says a lawyer shall not act as an advocate at a trial in which the lawyer is likely to be a necessary witness. A necessary witness. So what does this mean? So an example that I was thinking about prior to making this video is, let's say, for example, that I'm in a car with a friend of mine. My friend is driving the car, and I'm a criminal defense lawyer. I'm just your everyday guy making videos for YouTube. And my friend gets pulled over for a DUI. Well, I'm in the car with my friend. And so I'm a witness to everything that happened. I'm a witness to how much he had to drink before he got in the car, if anything. I'm a witness to how the cop pulled him over, what the basis for the traffic stop was. I'm a witness to the conversation that the cop had. I'm a witness to the field sobriety test. I'm a witness to all of those things. So if a defendant, if my friend came back into my office and said, listen, I know you were with me. You know this case better than everybody. By the way, I want you to represent me in court. That would cause a whole series of problems. You know, how can I ask questions of myself? How can I sort of set up myself to deliver testimony that's going to be a bombshell, massively positive for my friend's case? That's what my incentive would be. And so it's hard to do a cross-examination in that type of situation. It's hard for the prosecutor to come and ask me questions because I'm the lawyer and I'm the witness. And it creates some perceptions of bias and there's all sorts of reasons why this is a bad idea. You want to keep people separate. prosecutors should be separate from the witnesses, and the witnesses should be able to testify on their own independently of any undue influence from prosecutor's office or from defense attorneys or from cops or from anybody else. They should be unbiased and they should be authentic, and we should be able to trust them and understand that they are credible witnesses. So when an attorney sort of minces these lines, it's a problem. And so what does that have to do with George Floyd? It makes a lot of sense in the context that I just described it in, but what about in this particular case? And so let's go back through the timeline. I want to run through it briefly so you can recall what happened with George Floyd. Here we have on May 25th, 2020, George Floyd dies. His body was received by the medical examiner's office on that same day. So Hennepin County receives George Floyd's body on that day. The very next day, the Minnesota Bureau of Criminal Apprehension, otherwise known as the BCA, says that they're going to review with the HCAO, which is the Hennepin County Attorney's Office. So in other words, the BCA is going to confer with the HCAO, and they're going to assign these two attorneys who are going to be Mr. Sweezy, Mrs. Sweezy, and Mr. Lofton. Dr. Baker, who does the autopsy, then meets with the BCA, the FBI, and the same two prosecutors, and he reports his preliminary findings, but says that they're preliminary. They're missing some things. They're missing the toxicology reports and the video evidence. The next day, so 2 days later after George dies, Dr. Baker then meets with Freeman, who is the Maine County Attorney, meets with his subordinates, the Chief Deputy, Andrew Lefevre. We've got the Managing Assistant County Attorney, Amy Sweezy, and then we've got the Senior Assistant County Attorney, Patrick Lofton. So you've got 4 attorneys now who are all meeting with this Dr. Baker. And they're meeting very privately. The motion goes through a lot of detail to say that they limited this contact and they kept things very, very tight because they knew that the public was up in arms over this case, and rightfully so. And so they wanted to protect this information. They were being very cautious about it. And so these 4 prosecutors, all of them very, very high up in the prosecutor's office, are meeting with Dr. Baker, and they're doing it in privately, and they're doing it without any other non-prosecutor witnesses. So it's just these 4 lawyers who are prosecutors and Mr. Baker. This is where the judge is having issues with it. The government's motion, again, this is all facts that are based from the government's motion. The government drafted this. These facts come from their opinion. We don't have the defense's response to this. If they're going to be filing a response, we don't have any written orders from the court. All of this is coming directly out of the prosecutor's mouth. So take that for what it is. But we're going to be charitable, and we're just going to say that we're going to read this motion in the light most favorable to them. So we're going to do that, and we're going to say that we're going to take this for as true as we can take it. So Lofton, who is one of these prosecutors, then writes a memo. He says that Dr. Baker on the 27th told them the same things that he did on the 26th, but he gave us some more information about the prior injuries to Floyd and other times that he was in the hospital. Then on May 31st, Dr. Baker again has a video conference with Lofton and Sweezy. This time he discusses the toxicology reports that were done by an outside lab. And then finally, a couple days later on June 3rd, Lofton and Sweezy, they withdraw from the prosecution team entirely for unrelated reasons, and a new prosecutor is assigned. So these are really the problem dates: May 26th, May 27th, and May 31st. Those are the days that the Hennepin County Medical Examiner, Dr. Baker, is meeting with these 4 prosecutors. And so we don't know really what the judge's issues were here, other than sort of presuming the fact that this was kind of an unethical meeting, or they should not have had this meeting without a non-witness or a non-attorney witness present. The reason being is because they want to make sure that there's no undue influence going on here. They want to make sure that these 4 prosecutors are gathering information from Dr. Baker. They're not creating information with Dr. Baker. They're not having a conversation about this information. Oh, Dr. Baker, are you sure that it wasn't the drugs? Are you sure that it wasn't that fentanyl in there? Or maybe the fentanyl really doesn't matter. Or maybe it was more about, maybe he intended to kill him. Maybe there's more evidence of, could they be manipulating the conversation one way or another? Now, this is not saying that they did. Don't see any evidence on that here, other than the fact that the judge ruled against them. The judge listened to something in those oral arguments on Friday and decided that they all needed to be disqualified. Now, there is a lot of confusion about what the judge actually said, and the government admits that themselves. The government says in a footnote in their own motion that they really don't know exactly what the court did, and I can understand some of their arguments here. Let's take a look. The parameters of the court's oral ruling from the bench are not entirely clear. This is what the prosecutor says. The state certainly understood that the court's order prohibited the named attorneys from appearing as courtroom advocates, but the court's ruling also suggested that the named could not participate in the case beyond administrative duties. So what does that mean? Mr. Freeman was elected, that is the county attorney. He's responsible for overseeing the management of the cases. He has assumed all of this stuff. And basically what they're saying here is that if the court prohibits Hennepin County Attorney's Office from being involved in this case, that's a major problem with the separation of powers. Remember, we have three co-equal branches of government. Two here are working with one another. We've got the courts and we've got the executive branch, which is being embodied through the prosecutor's office. The prosecution is a body, an arm of the executive branch, and they are sort of battling with each other right now. The court is saying you're disqualified, but the prosecutor's office is saying you can't disqualify us. We're a co-equal branch of government. How dare you, sir? And they're saying you need to reconsider and let us sort of back on the case. If you try to exclude us, you're excluding a co-equal branch of government, and you don't necessarily have the authority to do that. So that's what the government is saying there. Now, they've also got some pretty good arguments going back the other way. Now, this judge already issued this order. It's already standing. And so they have to convince the court to reverse itself, essentially. And what are they asking, or what are their arguments to that effect? They're saying that none of the prosecutors, none of these four prosecutors who were part of the judge's order prohibiting them from being involved in the case, none of them are actually necessary witnesses, is what their argument is. They're saying, yeah, they may have been in that room and had that conversation, but they're not needed to come into court to testify. The defense, or in this case, Derek Chauvin's lawyers, they can get all of the information that they want or they need out of Dr. Baker. They can actually just ask him the questions that they want, and he's going to be inclined to give them all the answers. They can ask him about undue influence or unethical conversations. They can really dive into the nuts and bolts of what happened at those meetings. And so none of those other attorneys who work as prosecutors, none of them are even necessary. Therefore, this rule doesn't really apply to them. They can get all the information they want out of Dr. Baker. They are also making the argument that those four attorneys, they're not even the attorneys on the case. So they're not even advocates. So how can they be subject to the advocate witness rule if they're not even going to be advocates in the case? Hennepin County Attorney Office, these high-level managers and these deputy chiefs and assistant chiefs and whatever scheme they have there of organizing their hierarchy, many of those people are not going to be in court doing the advocating. That's going to be reserved for the attorney general. The case has already been reassigned, and so they're just saying, well, what is the court even saying that these people are prohibited from? They're not even on the case anyways. They're just involved in the county attorney's office. And so that's another argument they're making. And finally, they're saying that the ABA, the American Bar Association, and a lot of the ethical rules that they're citing also say that it's totally proper to have these types of meetings. They encourage one-on-one meetings between prosecutors and witnesses. And here we had 4 experienced prosecutors. Therefore, there can be no misconduct. And so that's what their arguments are. We're going to see what the judge has to say about this. And we looked previously, we know that the next court date coming up is going to be on 9/18 in the George Floyd case. They're going to have additional arguments or an additional proceeding, or we may get a ruling on this motion, or the defense may respond. So a lot of interesting things happening here. I mean, this is something that does not happen often. You do not see a judge, especially on a very high profile case, disqualifying the county attorney and 3 of his top subordinates. You just don't see that. So it's going to be very interesting to learn more about what happened on that Friday omnibus hearing court proceeding, because we just don't know a lot about it yet, but we can glean a lot of information from the state's response. And certainly they do not want their most prestigious attorneys in their office to be disqualified from a case of this magnitude. So it will be very interesting to follow along. We hope you follow along with us, which is why you should absolutely hit that subscribe button. And if you like what we do on this channel, if you like these types of analyses, these deep dives that we do here, do us a favor and share it with your friend so that they can also be a part of the conversation. We host a show here every Wednesday called Watching the Watchers Live, where we hold police, prosecutors, judges, politicians, and anybody else in the criminal justice system accountable, because we believe that transparency, sunlight, is the best disinfectant and the best way forward for helping to create a more just justice system. So hit the subscribe button, tune in. We'll see you on the next one. Thanks for watching.